Well, welcome. This is the U.S. Law Institute's speaker series. I'm Jose Alvarez, the faculty director. I'm delighted to present this talk, and it is honestly a talk because we've restricted our guests to 15 to 20 minutes for a 450-page book. So obviously, we will have a conversation both among the folks who are here as well as those online. So I welcome you to this talk on international law for whom. The speaker is talking about his book just published by CUP 2025, The Law and Politics of International Legitimacy. And Professor Jean-Marc Coicaud is a distinguished professor of law and global affairs at Rutgers University. He's an elected member of Academia Europaea and a distinguished chair professor at Fudan University in Shanghai, also a visiting professor at Tsinghua in Beijing. And before he joined Rutgers, he worked for the UN Secretary General in particular, and before that, as a senior academic advisor in the UN University, a think tank very much associated with the UN. He has also served as legislative assistant in the European Parliament and a cultural attaché with the French Ministry of Foreign Affairs. He's been a visiting scholar at Academia Sinica in Taipei. He has extensive experience and lived in China for a number of years, which is one reason why a book of this breadth is in this speaker series, because I think it reflects that breadth of experience both in academia as well as in politics and at the UN itself. He is authored or co-authored or co-edited 18 books, published over 100 articles in law, politics, and international affairs. And it's part of a trilogy, this book. The next one is on the globalization and fairness, including economics, which will be interesting from someone who has been trained in legal and political theory, but he's also got graduate degrees in law, philosophy, political science, and literature, so gets set for a Renaissance perspective. I will turn it over to Professor Coicaud for 15, 20 minutes, and then we'll have a conversation and then open it up to the floor. So it's all yours.
Thank you, Jose. Thank you. And thank you for being here this afternoon. So first of all, I would like to thank Professor Alvarez for organizing this session this afternoon. I also want to thank Yuan Gao, Amy, for helping us to put together this event. So when we discussed the organization of the session, Professor Alvarez suggested the title International Law for Whom as a theme for today, and I thought this was an excellent idea as the title captures many of the central themes of the book I published this summer as dedicated by Professor Alvarez, and so the book serves as an occasion for this afternoon gathering. I have been given 15 to 20 minutes for my presentation.
I'll keep the time.
Yes, so I'll keep it brief. Of course, I will not be able to cover all aspects of the book, especially since, as you mentioned, this is a rather long book, but I'll do my best to mention some of the most significant themes I explore in the book. And I'll be happy to share ideas and engage in discussion with the audience afterwards. So let me see how it works. Yes, so this is the cover of the book and so on. So the title of the book is The Law and Politics of International Legitimacy. But in fact, as Professor Alvarez rightly intuited, the subtitle of the book could very well be International Law for Whom. So why is it that the subtitle of the book could very well be International Law for Whom? So I think that it is the case because by addressing the issue of legitimacy in international law, but also the issue of legitimacy of international law, the book in essence is grappling with the two following questions. First question, whom does international law serve? And more specifically, whose rights does international law express and defend? And because the answers to these questions are, I think, far from settled, because in fact they remain quite open to debate, indeed, the question of legitimacy lies at the heart of how international law is conceived, interpreted, and implemented. So I'll give two simple examples as a way to illustrate this point, but indeed, questions of legitimacy are the center of how international law is conceived, interpreted, and implemented, and how it has to do with the question, international law for whom. So one example concerns the tensions between the rights of states, or sovereignty, if you will, and human rights, and the other concerns the tensions between countries of the global south and the developed west. So first, the relationship between state sovereignty, or rights of states, and human rights. Of course, this relationship, the relationship between these two sets of notions, shouldn't be reduced to mere tension. The two can and often do complement one another. Sovereignty, of course, we all know this, can support human rights. That was certainly the view of those who fought for decolonization and self-determination. But there are also times when sovereignty, the rights of states, and human rights come into conflict. And when this happens, we are indeed faced with a legitimacy dilemma. Which principle takes precedence, sovereignty or human rights? Or, to use another expression, should we give more importance to the principle of sovereignty or to the principle of respect for human rights? Hence the question, indeed, international law for whom? So, as such, this is fundamentally a problem of legitimacy, keeping in mind that each of these principles, sovereignty and human rights, represents a piece of international law legitimacy. So this is one example, somehow, as a way to show that indeed at the core of international law you have issues of legitimacy and that they have to do with international law for whom. The second example illustrating this reality concerns the global south and the developed west, and of course nothing of what I say here is really rocket science. We know all these things. Let me give you still my second example. It's clear that these two constituencies, the global south and the developed west, do not always see eye to eye regarding the role of international law, that is to say whom it serves and which values and interests it expresses. The global south tends to see international law as a Western construct that primarily serves the developed West, its values, its interests. As a result, it often questions the legitimacy of international law. As for the developed West, on the other hand, while acknowledging the need for further development and reform, further development of reform for international law, so the developed West tends to view international law as, and in fact views international law as a valid normative and legal framework for managing international affairs. And in this context, in the context of the developed West, the legitimacy of international law is often assumed. So it is often assumed, but not necessarily examined, let alone demonstrated, which of course is an issue. In fact, very few international law scholars in the US and in Europe, I come from Europe, have seriously explored the question of legitimacy in international law, or the question of legitimacy of international law, which is of course a bigger question. In fact, both for international scholars in the US and in Europe, the topic of legitimacy has not been a strong topic of interest for them. I was checking yesterday the work of Martí Koskenniemi, and himself somehow doesn't seem to think that there is much to fun and to think about in the issue of legitimacy. But an exception has been Professor Frank, Thomas Frank, who, as you perhaps know, taught here at NYU Law School for many years, and really in this domain, the domain of legitimacy is truly foundational to this discussion of legitimacy and international law. In any case, so in choosing this title, Professor Alvarez was right. It makes a lot of sense to think about the law and politics of international legitimacy through the lens of the question, international law for whom? Having said this, my book is structured around 5 main questions. First of all, what is legitimacy in general? We use the term legitimacy all the time, both when it comes to domestic politics and international politics, but we don't necessarily look into what it means indeed. And so the first thing that I try to do in the book is somehow unpacking what is meant, what we should mean by legitimacy in general. In fact, I addressed this question in a previous book published 15 years ago, in which I defined legitimacy as the recognition of the right to govern. In fact, at the time when the book was published in Mandarin, so it is also available in Mandarin. And so, what is legitimacy in general? Here the key question, which is of course a normative one, is what are the conditions under which the exercise of power is legitimate and just? And clearly there is a strong connection between legitimacy and justice. Legitimacy normatively is grounded in justice and in fact can be seen as a manifestation of justice. So this is the first question that I try to explore in the book. The second question is about the following. What is the relevance of legitimacy at the international level? And I tend to think that this, of course, requires us to take into account the specificities of the international community. And in the book, to answer this question, I refer to the diversity of cultures, but also of levels of development at play at the international level, but also refer to the fragmentation, in fact, increasing fragmentation of power in the international community. So thinking about legitimacy at the international level calls for thinking about the diversity, the fragmentation of the international community and what it means for the conception and exercise and projection of power. The third question that I try to think about is really focusing on international law. What does international law, or how does international law construct a sense of legitimacy? And here I explore this question. I try to give an answer to this question by exploring the following themes. First, the theme of international membership. And here the key question is, what does it take for a collectivity, for a group, to be recognized as a full-fledged member of the international community? The second theme that I try to mobilize as a way to indicate how international law constructs a sense of legitimacy has to do with international rights holding and the hierarchy of rights. When it comes to rights holding, I refer to the right of having rights, to use the expression of the German philosopher Hannah Arendt. So what does it take to have the right to have rights at the international level? This is what I try to explore in this part of the book. And when it comes to the hierarchy of rights, this question, this theme concerns the fundamental principles of international law and the hierarchy of importance that exists among them. And here clearly two key principles have to do with sovereignty and human rights. The third theme that I touched upon as a way to indicate how international law constructs a sense of legitimacy is rightful conduct. And here this theme refers primarily to the conduct of states vis-à-vis other states, but also to the conduct of states vis-à-vis people within and beyond borders. And finally, there is the theme of international authority, and this theme mainly concerns the role of the UN, especially when it comes to interpreting and applying international law through its various organs and so on. The fourth question that I try to address in the book has to do with the limits of international law but indeed leads us to question the legitimacy of international law and to question legitimacy in international law. And finally, the last question that I try to tackle is how can we make international law more just and legitimate, keeping in mind that indeed, in many ways, international law today, from within and from afar, is being challenged. Its legitimacy is being challenged. And so, in order to answer this final question, how to make international law more just and legitimate, I, among other things, reflect on how to build on the progressive dimensions of international law to enhance, to maintain, to preserve the legitimacy of international law. And on this specific point, how to make international law more just and legitimate, I make a number of suggestions in the book. Professor Alvarez mentioned that I was trying to put forward the idea of international rule of law, which is true. So, and among these suggestions, I mentioned the two following suggestions. That is to say, I think it would be important for us not to think that sovereignty is the end. I tend to think that the final normative foundation of sovereignty is the welfare of people. And then the second suggestion, and so I elaborate on this, and the second suggestion is about trying to promote a sense of international law, or, if we want to dream, a sense of global justice that would go beyond a purely Western agenda. Global justice, international justice were big themes in the 1980s, 1990s, early 2000s, but it was essentially a Western agenda. And I don't think that the West beyond, I mean, the world beyond the West is going to be on board on an essentially Western agenda when it comes to international justice, global justice. So this is what I just talked about. So as a way to end my brief presentation, I was given 15 to 20 minutes. Let me now add that since this event is organized in the context of the US-Asia Law Institute, the book owes a great deal to Asia and reflects extensively on Asia's role in shaping today's international legal order. As I mentioned in the book, I first began thinking seriously about the need to write this book while living and working in Tokyo. Japan is in many ways a highly westernized country, but it also has a rather unique culture. And as such, I think that it maintains a complex relationship with the West. On the one hand, Japan strongly endorses the legitimacy of international law and strives to be a responsible member of the international community. On the other hand, I think that it harbors some ambivalence about international law legitimacy. And from this vantage point, the work of the Japanese international law scholar Yasuaki Onuma, which I had the privilege of working with in Japan and whose ideas I explore in the book, is, I think, particularly insightful. In the book, I reflect on Onuma's call to revisit the universality of international law and to make it more trans-civilizational. His term for an international law that would be more mindful of cultural plurality and more inclusive in its foundations. I'm not sure that this idea that Professor Onuma is putting forward is fully realizable for various reasons, but I do believe that indeed there is a need, strong need to somehow internationalize or de-westernize a bit international law and the global system. And in many ways, this process is already underway as the international order becomes increasingly multipolar with the rise of emerging countries. Ultimately, this may call for a kind of international law that is both, or that could be both universal and pluralistic. The question here, however, is how can we establish a single international law, to use your expression, Professor Alvarez, that is at the same time universalistic and pluralistically acceptable to all. From an institutional point of view, it's already a very, very difficult task. What kinds of institutional reforms could help achieve this? But from a normative point of view, I think it's even more difficult. How do we identify and agree upon norms that can at the same time uphold universality and embrace pluralism within a single paradigm that brings people and nations together. This is obviously not a small task. Which brings us to the central theme of the day, international law for whom? The book also draws heavily from what I have learned during my time in China. In fact, I drafted the first version of the book in Shanghai while on sabbatical a few years ago. And over the years, my affiliation with Chinese universities has given me insight into how China perceives international law and its legitimacy, insight that I have tried to incorporate into the book, although of course I'm not a specialist of China or of Chinese law, so this is the caveat. It seems to me that China's relationship with international law is also, like Japan, but in its own way, dual track. On the one hand, China is an active member of the international legal community. It wants to be seen as taking international law seriously, even if its perspectives differ from those of many Western countries. On the other hand, China is also challenging international law, both from within and from outside. From within, by resisting compromise, for instance, on issues such as human rights, and from outside, by building international alliances and institutions that compete with Western-dominated frameworks. For instance, the Shanghai Cooperation Organization and China's leading role in the BRICS, particularly through institutions like the New Development Bank headquartered in Shanghai, are noteworthy examples. So in doing so, China is advancing a strategic and pragmatic agenda at the same time for reshaping international law and international order. The question is, how is China likely to succeed? After all, one of the West's strengths in building legitimacy into international law has been its reliance on democratic values first and developed domestically and then projected internationally. Western values, though rooted in the West, also emphasize principles like equality, which is why they have often been mobilized by the Global South to assert its own rights in the context of decolonization. So what kind of, I think the final question is, what kind of normative resources might China offer as it seeks to build a legal and political international order that others might find appealing? I think that's a key question for the way forward. So I'll stop here, just 20 minutes, and thank you for your attention, and I'll be happy to answer your questions. Thank you.
So one of the things that's striking about the book is that, like some of the best books in the area, it's both descriptive and prescriptive. You're describing a situation of how a political authority is justified through international law, but you're also giving prescriptions of how to do it better. And I guess one question, since you've been around, why is it that political philosophers tend to ask this, but not international lawyers, putting Tom Frank aside?
Yes.
Although, as you say, Onuma really
Yes.
is addressing that. So can you say a bit more about why this is an underexplored topic? And do you think it's also underexplored in Japan and China?
So why is it? So first of all, why is it that in the West, legitimacy is not addressed as a relevant issue for the understanding and the analysis of international law? I think that the simple reason is that because we assume that indeed there is a legitimacy to international law.
Because we made it.
Yes. So there is the assumption that we don't have to really spend much time on this because indeed it's legitimate.
And there lies the problem.
Yes, of course. But of course the views that we encounter in the non-West, be it in the Middle East, in Asia, elsewhere, are quite different. In fact, the legitimacy of international law seen from afar is quite problematic. Hence the fact that indeed there is an interest for thinking about legitimacy within international law and for thinking about the overall legitimacy of international law. But since the scholarship of international law has essentially been produced by the West, in fact, not much attention has been given to the topic. Mr. Onuma is quite an expert in international law from a Western perspective and from a non-Western perspective, and therefore he has been interested in the question. But he's one of the very few people having focused on this.
Right, and you mentioned his trans-civilizational
Yes.
approach, which is actually one of the first books that we introduced when we taught a colloquium on Asian perspectives on international law, and yet you don't fully endorse it in the book.
Yes. So first of all, I mean, you know, I don't think that I would have thought about the need somehow to internationalize international law if I hadn't spent time in Japan and China. So somehow, you know, I used to work for the UN, I worked for the UN for a very long time, and in fact thinking about the legitimacy of the UN in New York is not really the focus. And it's really by spending time in Japan, in China, that I came to think, wait, we have to somehow distantiate ourselves from how international law is viewed in the West as a way to think further on what it is, what it should be. So for me, spending time, and maybe, you know, the evolution of my thinking would have been the same had I spent time in the Middle East or in Africa. I mean, I think it was very important for me intellectually to spend time beyond the West as a way to reflect from afar on the nature of international law, its role, and what perhaps would need to be done as a way to enhance its legitimacy for the way forward. Yes.
So no, but I guess I was curious what you thought of Onuma's specific proposal of trans-civilizational approach. And you say it's hard.
Yeah, I mean, you know, I think he's very, very good at somehow unveiling the assumptions of universality, of truth at play in international law as we understand it in the West, in Europe, in the US. But he's not so good at giving us the methodology that we could call upon as a way to make international law more pluralistic. So it doesn't really tell us what would be the ways in which or through which we could make this happen. The second reason why I'm a bit skeptical is that somehow international law has grown globally out of somehow transforming domestic legal landscapes. I mean, most domestic legal landscapes around the world have been westernized. And these domestic legal landscapes, westernized, are the foundations of international law. And in a way to internationalize international law, we would have to also address the domestic foundations of international law. And these foundations have been, to a very large extent, we have to deal with hybrids, legal hybrids all around the world. They have been westernized, so somehow the domestic foundations of international law are themselves not so international. So I think that's a major difficulty.
And perhaps Onuma was focusing too much by focusing on the term on cultural values,
yes.
Asian values,
yes.
and as you say, that gets more and more complicated as globalization hits.
And also another difficulty is that it's about the identification of what should be uniformized, I mean, what should be homogeneous in
right.
terms of norms and so on and so on.
Right.
And so what is the uniformity that is acceptable and the one that is not acceptable, and what is the diversity that is acceptable and the one that is not acceptable? How do we draw the line, and where do we draw the line? This is very difficult.
Right, and here's a perfect area where it is. Universal human rights.
Yes.
Under challenge now by one of the fathers of human rights, the United States itself, long under challenge by many countries in Asia, which has tried to promote Asian values in the course of that, suggesting that perhaps the search for universally applicable human rights, fundamental norms for how you treat the person, is a lost cause, yet you defend the future of human rights.
Yeah.
How?
Well, I think that the key, and I'm not saying that stating what the key is brings about the answer. I don't have the answer. But the key is to detach as much as possible, or to disconnect as much as possible, a human rights agenda from a philosophy of power. I think that one of the reasons why very often human rights are being criticized beyond the West is that somehow people feel that there is a strong connection between the human rights agenda and the philosophy of power, of Western power. Very often the thinking is, this is an expression, this is an instrument of Western power. So the key is, how do we put forward and give credibility, give strength to the human rights agenda by somehow dissociating this agenda from power. So that's the issue. How do we do that? This is difficult. and while in the process not losing the credibility of a human rights agenda.
So the other prominent space given in the book is to the United Nations. And yet the United Nations as that romantic ideal of 1945 seems a long distant dream. We just had a speech by the current US president that sounds like, maybe I'll stay, maybe not, but in the meantime I won't pay for it. What's the explanation, not just for the US behavior, but I'd say for the loss of the UN's, say, you call it symbolic and political charm?
Well, I mean, yes, I mean, you know, I live near the UN in Mid-Manhattan on the east side.
And you like that building? Never.
No. But I see thousands of people every day visiting the UN, right? Mm-hmm. So, and you know, in the UN building you have bad art, bad paintings, so they don't come here for the art. I think they come here for the idea. Right. This romantic idea of, you know, we belong to different cultures, our countries have different interests, still, you know, we can come together and work together. So, as you mentioned, this is a romantic idea. And as you rightfully mentioned also, the romantic idea of the UN has faded away. So why is it the case? I mean, one reason would be lack of results. I mean, when you think about the situation today in Ukraine, the situation in the Israeli-Palestinian conflict, I mean, you cannot say that the UN is doing well. I mean, it's doing anything actually. So paralysis and lack of result is, I think, a factor accounting for the fact that people have come to be disenchanted with the role of the UN. The second reason, and this is something that my former boss, Boutros Ghali, used to argue about, that is to say the sense of co-responsibility. I mean, when the UN is doing well and doing good, I think, you know, the responsibility for this has to be shared between member states and the UN. When the UN is doing nothing or, you know, pitiful things, the responsibility has to be shared between member states and the UN. And I end up thinking that somehow the commitment of member states to the UN is very, very minimal. I mean, I don't know if you have in mind this novel, Dr. Jekyll and Mr. Hyde, which is a British novel that we read when we were kids. And in Dr. Jekyll and Mr. Hyde, at night, I mean, during the day, Dr. Jekyll is a doctor, during night, he's a monster. Well, I mean, yes, member states tend to be a bit, they tend to have this kind of dual identity. And very often they are oscillating from one to the other, but in these days, today, they seem to have chosen what is their real identity, which would be Dr. Hyde, or Mr. Hyde.
So this is one question. So you're right that the UN does not seem to be effective on many levels. Peacekeeping is a disaster in many respects, and so forth. And part of it is the lack of funding. And as the US seems inclined not to fund it, and you spend a lot of time in Europe, do you see Europe stepping up?
No. The short answer is no.
So how do we restore...
Europe is not even stepping up for its own fate in the context of the European Union. So why would it do so at the global level?
What about Asia, Japan, China? Will they step up?
That's one of the key questions for the future. Japan, I'm not so sure, because somehow the ability of Japan to be a central player today is not what we thought it would be 20 or 30 years ago. Somehow the global potential diplomatic existence of Japan has faded away, I think.
Is this an economic problem or a political problem?
Well, once the economic rise of Japan somehow stopped, the ability to translate this rise into diplomatic presence somehow faded away too. But I tend to think that even if Japan had continued to rise economically, it was not necessarily equipped to somehow translate its economic relevance at the global level into diplomatic and political relevance for a number of reasons, including, in fact, and I mentioned this as applied to China, because of normative resources. I mean, the strength of the West in terms of its normative resources is that it has put forward values that others could embrace, because democratic values were stressing the idea that we are different, but at the same time we are equal, and we can come together. At the core of Japanese values, I lived there for 6 years, there is the sense that Japan is quite unique. Each country sees itself as unique, but Japan somehow stresses the uniqueness of its cultural identity and its sense of self. And I think that makes it difficult for other countries to embrace such a stress on how different we are.
So,
and this is also a question partly that can be applied to China, although I think that there is more openness to the world in China than there is in Japan.
so let me pursue the China point. So last week we had contrasting speeches. Trump gave his all to selfishness, and China came off smelling like a rose when it comes to multilateralism, its commitment to the UN, even its newfound commitment to increasing its contributions on climate change. So is that an alternative? Can we expect that the change in international legal order will come about in part through a newly defined international legal order under the new hegemon, China?
I don't think that we necessarily need an hegemon. I think that an international law, an international order based on hegemony, I think is always dangerous. I mean, historically, in the past 30 years, 40 years, 50 years, we have seen hegemony as one of the key devices for the establishment of a stable international order. But we also have seen the downside of this. The criticisms addressed to the US have also to do with international order based on hegemony. I think that the same would apply to China. So I don't think that a happier model of international law and of international order would be based on an alternative hegemony, the one of China replacing the one of the US, simply because even though we tend to think that hegemony is a good device for international order, it's a dangerous one. Dangerous one for the world, but also for the hegemon. I mean, the fact that in a way the US has a target on its back, and China would have a target on its back.
So let me ask you a more politically delicate question. Is China's commitment to multilateralism genuine?
So that's why in my presentation I think that there is the pursuit of a dual track approach. On the one hand, it's very important for China to be viewed as legitimate, domestically and internationally. It's very important to be respected, to be viewed as respectable. And so the commitment of China to multilateralism, the commitment of China to multilateralism has to do with this partly. But at the same time, I think that China is also very, very committed to its own interests, hence the dual track approach. I mean, China always talks about the century of humiliation, and it is quite eager somehow to be to make sure that it is not once again cornered by history. So I think that that's partly, I don't know if I am right, but the engine of the dual track approach of China has to do with this. The need to be respected, the need to be recognized, but at the same time, suspicion about other powers, especially the West.
So we'll open it up for questions after one more question, so keep it in store, those in the room as well as those online. And I guess the opposite of those who say that China could establish a genuine commitment through multilateralism are those who see with quite alarm the rise of China's alliances, especially the parade of China alongside North Korea, alongside Russia, and possibly others. And there's a lot of talk on pages of Foreign Affairs of an axis of upheaval as an alternative. So is that a realistic fear?
I think the sense of partnership existing between today Russia, Iran, North Korea and China, I think from the point of view of China is limited. Once again, I think it's very, very important for China to feel respected and to feel respectable. I don't think that China wants to be in the business of creating chaos. So I think that there is a short-term interest in somehow aligning with Russia and so on, but I don't think that it is an all-the-way commitment to this alliance.
So it doesn't want to be a rogue nation?
I don't think so.
I
I don't think so.
So the access would have to be the other three.
And you know, China is eager to become a comprehensive power. When you think about Russia, you know, of course, it's a huge country, huge resources and so on in terms of natural resources and so on, but its power is the power of, it's a nuisance power.
Mm-hmm.
The ambition of China is to be a comprehensive power, you know, across the board. And I think that legitimacy is part of the agenda. So the question is, how does China, I think, once again, I'm not a specialist of China, how does China continue to aim for a more powerful position while fulfilling the demands of legitimacy that exist both domestically and internationally?
Right.
China doesn't want to be a rogue power. I don't think so.
Okay, and with that, we'll open it up for questions, first from those in the room. Silence all around. Oh.
I'm happy to begin. No, thank you very much. I haven't had a chance to read the book, but because you mentioned Frank, I always felt that one of the tensions in his work is that some understandings of legitimacy are more procedural in nature and some more substantive.
Yes.
And I wonder how you engage with that tension in your own book and in the project that you're putting forward.
Well, I mean, you know, in fact, on this specific issue, I build on a previous book, which was a book of legal and political theory. And the tradition tends somehow to disconnect procedural justice from a reflection on the substance of justice through values. I think that, for instance, the commitment that, for instance, Professor Frank had to procedural justice, fairness, was underwritten by a commitment to values, to substantive justice. We know we cannot really value, for instance, the rule of law as a procedure without ignoring the values, the substance of justice, underwriting this commitment to procedure. So we tend to view procedure as, you know, possibly as something that we could disconnect from values and substance. I don't think that it is possible.
So it's interesting because I think you're referring to his original book, which is Legitimacy, which was very much, so I'm thinking of the elements of his coherence, consistency, symbolic validation, all about the actual mechanics of law, almost procedural in nature, but he followed it up with a book on fairness.
Yes.
So I think that he accepted that there were two components to legitimacy.
And in fact, you see, a liberal understanding of justice tends somehow to put the emphasis on procedure. I mean, you also find this in Rawls, you find this in Dworkin, and so on and so on. But in fact, and I think that in the process, scholars, philosophers overlook the anchoring of commitment to procedure into democratic values, into values. And this is a point that I make in a previous book on political legitimacy.
Other questions?
I'm interested in your references to cultural values in Asia because I didn't expect to hear that.
Mm-hmm.
When we teach Japanese and Chinese law, I think we're very cautious about accepting broad generalizations about cultural values. And I would have thought that the objections to international law as being Western influence would be the connection between the use of international law and the use of actual power.
Mm-hmm.
So to make things more non-Western, it's still not clear to me exactly what non-Western countries have in mind or what they should be referring to, assuming that we think cultural values are relatively vague and ill-defined and probably will not provide a strong basis for changing the current view of international law.
Well, I mean, this is an argument that Professor Numa puts forward when he talks about a trend civilizational kind of international law is putting forward the idea that there is a need somehow to factor in, more than it is the case, the cultural foundations of polities, of civilization, that's what he talked about, in international law. I don't know why we should overlook the importance of cultural values. I mean, you know, I lived in Japan for 6 years, and I mean, there is an heaviness to culture in any kind of country.
But I think Bruce is also focusing on, okay, assuming that culture is there and it's a problem, but it's hard to change and it's also complicated, what are the other dimensions of de-Westernizing international law that you have in mind? And I think you're talking about, when you talk about justice, I think you're talking about economic justice.
For instance, yes.
So I think if we don't return to the days of the new international economic order, which we toppled with Washington Consensus,
Yes.
but we learned a lesson from Washington Consensus, the next model has to be something else. But I guess that's what the question is.
Yeah.
What kind of change in international economic law would you see increasing its authority, its legitimacy in the global south?
Yeah, no, I mean, the book that I am now writing is on these issues, and you know, my experience, both you know, beyond the West and at the UN, is that, you know, people and polities, I mean, groups, they want to experience a sense of agency. And very often, you know, beyond the West, people feel that somehow this sense of agency has been taken away from them. So from a variety of ways. So how do we somehow allow for international law, for international economics, being a tool for the regaining, the reclaiming of agency, individual and collective? I mean, in a way, self-determination is all about this, collective and individual agency. And there is this, I mean, you know, you cannot really overlook the importance of this feeling. You know, you travel a bit to Africa, you travel to Middle East, you travel to Asia, people feel that somehow they have been alienated. So how do you allow for the regaining of this sense of agency? I mean...
Right, well, I expect your book would have to deal with, for example, the Sustainable Development Goals.
Yes.
And how do you achieve them? Assuming you want to achieve those 17
Yes.
goals, and that the Global South tends to support all those goals, because how can you resist, you know, lowering infant mortality, etc. I suspect that what they might say is some version of give us the resources, which may include more sovereign debt relief, more both political, that is state aid, but also more private investment going to, say, green energy. Is that the kind of recipe that your book, just to anticipate what the third volume will look like?
You know, for this book on globalization that I am trying to write now, I'm trying to think about the kind of partnership that was established between the Western corporate sector and China. And it's interesting because in the US and in Europe, the corporate sector is very anti-state, anti-public sector. But in fact, the primary partner of this Western transnational corporate sector in China is the state. So what does it mean? I'm trying to think about.
Well, I think the U.S. is changing its mind about the role of the state, right? Once we own TikTok, I think
Yes.
that'll affect. More questions?
There's an online question.
Oh, please. Yeah.
So I'll just read this. It's a bit confrontational.
Mm.
International law, and domestic law for that matter, is written by a very small oligarchical elite supported by oligarchical institutions. Therefore, it's logical to follow that international law doesn't help much with anything except prolonging conflicts, strife, and exploitation. Do you think we have a problem of principles and morals in setting up the framework of international law, or is it a problem of lack of power and enforcement?
Well, the last part of the book is trying to think about this question. I tend to think that, in fact, the nature of international law is, by definition, ambiguous or ambivalent. On the one hand, it is conservative or pro-status quo, to the extent that it is an expression and a projection of the Western power. But at the same time, there is also a progressive dimension to international law as expressed by human rights and so on and so on. So the key for the way forward is somehow to build on the progressive aspects of international law, and once again, I'm probably dreaming, thinking about ways through which you could somehow detach these progressive aspects of international law from being the captive of power dynamics.
There is a section in the book where you address the canard, I think you would call it, that international law is all about the status quo, and it's all about stability and protecting so-called legitimate expectations, and therefore the legitimate expectations of the rich or the oligarchs in this case. And you counter that with a description of the many ways international law and legal order incorporates change.
Yes, absolutely.
And so that's where I think you're leaning in the book.
Yes.
The ways international law takes on, sometimes bottom up or horizontal, but from the global south, pushes to change.
Yes, in fact, there is greater fragility for an order totally opposed to the possibility of change than to an order, legal, political, economic, somehow internalizing the possibility of change. I mean, think about I tend to think that authoritarian regimes are much more fragile than democratic regimes, because somehow they lead to the radicalization of opposition, because they make little room for opposition. So the key, I mean, that's why somewhere in the book I talk about the goal shouldn't be stability, the goal should be socializing instability.
Interesting. Any other confrontational questions from the chat box?
I want to ask one of my own. So this is, of course, the 80th anniversary of the UN. It seems like a perfect opportunity for the kind of rethink that you're calling for. And I thought, actually, of all the and I didn't read or listen to Trump's speech in full, but he raised the question. I actually thought it was a good question of what is the UN for? I mean, that is, to me, a very good question to raise. And the 80th anniversary ought to be a time to think about it again. Maybe whatever the UN was for in 1945 is different now, right? You know, the world has changed. So what might be a way towards having, now I'm going to slide into the kind of language we use here in the States all the time, having a public conversation, you know, starting some kind of a discussion about what the UN should be for, or what a reimagining, not just, I know that there have been institutional conversations at the UN about how do we reform the Security Council, how do we redistribute power, there's that. But I mean a people's conversation that would engage perhaps international civil society or scholars and or just plain old folks about what would we want if you could have the UN do something that you thought needed to be done and that was uniquely qualified to do, what would that be? How could we do something like that?
Well, clearly we're not having this public conversation. I mean, we're not having it at the UN, among member states, and even when it comes to the public at large, we're not having this conversation.
So we need a moral lead, we need somebody to lead it.
Yes.
But somehow nobody comes to mind.
I think, you know, we're all brain confused, and we're accepting the reality of brain confusion as if it was unavoidable.
Yeah. I
mean, but nobody, I mean, this is true at the international level, but also at the domestic level. I mean, in Europe is a mess, and it is also a mess when it comes to the situations of country. I mean, if we don't want to acknowledge the problem, we're not going to find the solutions. And I don't think that we are focusing enough on what are truly the problems to be able to find the solutions.
But Catherine is absolutely right that the UN 80, which is a broad set of reforms, probably more intensive and more serious given the crisis in funding that it faces. So this is probably the most pressure the UN has ever faced. But the UN 80 reforms is not revisiting the Charter. It is saying, here are the things we're supposed to do. The principles and purposes are peace and security first, development, and human rights. Those three are the three pillars, and then the way forward is how to do that better. And they focus on overlapping mandates and making sure that we use the money more wisely, and also firing people if need be, but not the fundamental question.
And I don't think that there is much strategic thinking at play, and there is not much strategic thinking at the play because I don't think that these suggestions for reform are factoring in the ecosystem in which we are today.
You know, it would have to be, and I think Catherine is suggesting that, leaders that are not necessarily within the organization.
Yes.
The organization is a bureaucracy. Bureaucracies protect path dependencies and all sorts of things. I don't think Max Weber would have said bureaucracy is going to reform itself. So that is the challenge. How to construct something that is both about the UN but outside of it is a real thing. Maybe we should have a speaker on that. I think we're running.
That I can do, I can't solve
But this requires some sort of hybrid knowledge. You as a way to reform the UN, you want to have a sense of what the UN is. You have to know how it works or it doesn't work. But you also need to somehow not be the captive of what the UN is. And this hybrid knowledge is not easy to find.
On that note, we have to end because I see it 4 o'clock. It always goes a little fast, but help us thank ourselves.
Thank you.